The next bill on the agenda is Senate Print 1553C by Senator Myrie.
An act to amend the criminal procedure law, the executive law, and the correction law in relation to automatic sealing of certain convictions.
Senator Myrie.
Thank you. And let me just express my deep gratitude to the chair for bringing this on the agenda. I think all of us are pretty familiar with this bill, not just because of what has been discussed in the public sphere, but we passed this out of committee last year. And so I really want to just give the opportunity for colleagues. I'm sure there will be some questions and some exchanges. So again, just much appreciation to Senator Bailey, to Dorothy for getting this on the agenda. And I look forward to us finally getting this to the floor and passing it.
Thank you, Senator Myrie. We have a number of questions. First is our ranking member, Senator Palumbo.
Thank you, Chairman, and good morning, everyone. And I just have a few questions regarding, I guess, some of the technical nature of it, but it's a C print. And the way I read it, just to be clear, I don't know if it's yourself, Chairman, or Senator Myrie or Dorothy, but only sex offenses are excluded from sealing. Is that accurate?
That's right.
Okay. Thank you, Senator Myrie. And so obviously homicides would be sealed automatically after 7 years after release from prison under the terms of this particular statute, right?
Yeah, and let me just make a point, Senator Palumbo, because I suspect we're going to go down this offenses route throughout. The sealing doesn't apply if an individual is on parole or probation. For some of the more serious offenses like murder, you know this, Senator Palumbo, from practicing, that usually is accompanied by a lifetime of being on parole. And so in the overwhelming majority of instances, for some of the more egregious offenses, most individuals will never be eligible for automatic sealing.
Thank you. And I appreciate that comment. And regarding the agencies that will have access, right? We've got a list of agencies under the bill, law enforcement agencies, individual defendants, of course, would have access to their own records. But as far as any prospective employer that's not in law enforcement, can you tell me if there's because this is an exhaustive list, right? Everybody's exempt other than those listed. Can you tell me if there are any private employers that could ultimately have access to this information?
Go ahead, Dorothy, because I see you.
Sure. So the bill does establish that if an employer is required by law to conduct a fingerprint-based background check, and there are a wide variety of those employers, then any records sealed under this bill would be visible to those employers. So, for example, if I applied to get a job at a grocery store to be a cashier, that would not be something that any of I don't have a criminal history, but if I did and they were sealed, that would not be visible to that employer. If somebody with a sealed record, however, implied to be a school bus driver, there are both state and federal regulations that require that school bus driver to have a fingerprint-based background check done. In those circumstances, the sealed criminal records would be visible to the school bus driver employing agency, but not to the any other job that does not require that fingerprint-based background check.
And is there any, for those agencies that aren't exempt, Dorothy, is there any sort of an application that the employer could make? Say, for example, I'm running a daycare. I want to see if there were endangering the welfare of a child convictions. I believe that it's relevant to this manner of employment. Can they make any applications? Is there any way you can get off the list of non-exempt entities?
So for the record, daycares are required to do a fingerprint-based background check, but your point stands, there is no method in the bill to allow employers to petition for the ability to see these sealed records.
Thank you. And, I do have something, maybe you can address it because you've got a little more knowledge about this stuff than I, but I did receive some information regarding state education offices. The Office of School Personnel Review and Accountability, as well as the Office of Professions, would not be considered a qualified agency, is my understanding, and it was their concern from people from state ed. And the Office of school personnel review and accountability. In addition to moral character review of all licensed school professionals, they conduct fingerprint-supported criminal history background checks for prospective school employees. So would they actually have access to these in light of what you just said?
Can I jump in here for a second, Dorothy?
Thank you, Senator.
Really quick. So, we received those concerns from State Ed, I think just as you did Friday night. But I'll say that for both of the sort of subdivisions that they're referencing, one, I think, already has access. I think it's a misreading of the bill because even in their reference, they talk about fingerprinting for that. And so they would already be granted. And for the other office, my understanding is that in those procedures that any criminal conviction whatsoever constitutes professional misconduct. And so that is something that we're open to discussing and seeing how we might be able to incorporate that exception. But that is, my understanding is that for one of their concerns, it's already addressed. And for the other one, it's something that we're open to addressing.
Well, thank you, Senator. That was a significant concern. And I see some of my other colleagues have questions, so I won't be here all day. Obviously, if this gets to the floor, we'll talk a little more. But just by way of general comments, these are specific cases where individuals were denied certification clearance, where an individual is convicted of endangering the welfare of a child as a misdemeanor who sexually abused their stepchild, a teacher convicted of assault third who fed their child toilet bowl cleaner, again, misdemeanor. So, possession of a weapon. There are specific, an attempted assault and menacing of assaulting a child's mother while they were holding the child. So, obviously, this is critical, I think, to the safety of the public. I've been a no on this bill before. I will continue to be a no. It also requires sealing of all within 2 years of all existing records that fit the criteria. And of course, we have a fund we set up for the discovery reforms that is, in my opinion, insufficient to keep up with that burden. Now we're going to really add an additional burden without any funding to our law enforcement agencies in order to comply with the statute. And quite frankly, it's subject to debate with many of my colleagues as to the reasons why we have a crime spike. But I think we can all agree, regardless of our differences, there is a crime spike right now in not only New York State and the country. And to continue to do this sort of, progressive social justice, criminal justice reform, however you want to characterize it, I think is dangerous, that we have even more bills on this agenda that are looking to completely overhaul and change the system, not make minor tweaks. So I'm no, I urge my colleagues to also vote no on this, because now is not the time. We're coming out of a pandemic. Crime is rampant. Shootings are up from year to year. From 2 or 3 years ago, we have tremendous amounts of new victims as a result of something that we can debate. But we all agree that there is a problem with crime right now. And this isn't the time to do this. So I appreciate all of your time, and I appreciate the ability to comment. Thank you, Chairman.
Yeah, if
Senator Meyer, if you'd like to, please respond.
Yeah, if I could just respond, and of course I appreciate Senator Palumbo's comments. I'd characterize this as the exact opposite of something that is pro-crime. This is a public safety bill because individuals who have already been convicted, who've already been sentenced, who've already served their time, who are already out in the community, deserve an opportunity for housing, for education. Those are the things that keep people out of committing crime. That is. I don't think we can or should be debating whether or not giving someone stable housing and an opportunity to work will help keep them out of trouble. I also think that the bill provides an incentive for individuals who know that this is coming down the pike, that they will say, look, I know that I have to stay conviction free in order to take advantage of this automatic sealing. I'm going to continue to do that. And from a mentorship standpoint, you know this, and all of us know this from our work in our districts, that oftentimes when we come to people and say, this is a bad thing for you to do, you shouldn't do that, they don't listen to us. But if it's someone who has a conviction history, someone who's lived the life that they have lived, and if they come to them and say, bro, this is not the way, or sis, this is not the way, giving that person an opportunity to have a job, education, housing, that's also a crime fighting tool. And we have the largest employers in our state, like JP Morgan, like the Business Council, like Verizon, like a bunch of our labor unions, they're all in support of this because it is a jobs bill. It is an opportunities bill, and it allows, I think, for a more nuanced conversation around public safety. So hopefully when we get this to the floor, I'm sure we will have some more exchanges on the bill.
Sure.